We just finished the first panel discussion at today's Helsinki International Arbitration Day conference on digitalization and cybersecurity, new challenges to international arbitration. Your point of view as a chief legal officer of Sanoma was and is very interesting for the arbitration community as such. And in terms of the question of how secure are the means of the communication, we know that confidentiality, if it is not in all institutional rules codified, it is an unwritten principle of international arbitration. So where do you see the weakest link when it comes to the disclosure of information that would need to be confidential under the aspect of cybersecurity in particular?
I think we have two aspects here. Confidentiality on one hand, and then information delivery on the other hand. And when I look at companies that use arbitration and rely on arbitration over court proceedings, the main reason why they do it is confidentiality. They don't want to have their big issues being disputed in public. They want to rely on confidential arbitration proceedings. And yet, when I look at arbitration rules and Finnish law on arbitration, both are silent about information delivery. And in arbitration law, there is nothing about confidentiality. There are clear rules about information delivery in respect of how many copies need to be delivered, that there needs to be proof of receipt, and also that parties are treated equally, so that the process is transparent. But about means of information delivery, there is nothing. And yet, when you think about the volumes of information delivered in normal arbitration proceedings, that's huge. And if that happens over general email connection like Gmail or Suomi24 that we have here in Finland, it's easy to hack. And obviously of a great concern to clients. And when I look at this from a confidentiality perspective, it seems really cumbersome to enter into agreements with arbitrators about confidentiality and means of information delivery. So as a client, obviously, I would like to cover this weakest link, which is the information delivery part, and have some generally agreed principles in that respect, like any company does.
Right. That could be done, of course, by way of an agreement between the parties and the arbitral tribunal in terms of setting up special security measures when it comes to the delivery of information. Are the companies, the users of arbitration, are they willing to invest in that as well, in a specific data sensitive case?
As a monetary investment, I don't think it's a big investment to use secure email connection. So it can't be a question of money. I think it's more about awareness, right, and the easiness of hacking information that plays a crucial part in the proceedings.
Of course. So then I conclude that from a party's perspective, it is up to the council to bring that awareness about the security to the tribunal and also to the other sides, party and council, in order for the parties to agree on measures which are in some cases indeed not too expensive, and to fill the gap that the arbitration rules have at this moment.
Yeah, that would be very much of importance for clients.
Thank you very much.
Thank you.